The member for Mornington.
Thank you, Acting Speaker. I rise to speak on the Confiscation Amendment Unexplained Wealth Bill 2024, a bill which seeks to strengthen the unexplained wealth regime by better targeting leaders of serious organised crime and preventing the use and enjoyment of wealth obtained illegally. In Australia as a whole, it has been estimated that crime costs us nearly $36 billion a year, with drug-related crime representing a significant proportion of this cost. I can tell you that organised crime, and crime in general, is out of control in Victoria in particular. According to Assistant Commissioner Martin O'Brien, Victoria has become the epicentre of organised crime in Australia, with motorcycle gangs and crime groups fighting for control, for example, over the tobacco trade, and these profits often being fuelled back into the weapons trade, drug trade, and indeed human trafficking. As the member for Gippsland South said before as well, we've seen a 2/3 growth in the crime rate as well. And I've seen and heard from many on the peninsula as well, and in my electorate of Mornington, about increased break-ins and an increased crime rate, which is evidenced in the statistics for the peninsula, particularly in youth crime. Social media has also made it easier than ever for serious criminals to show off the proceeds of their crimes, shore up power and influence, and threaten their competition, as well as recruit new members and more. These flashy displays of wealth often seem attractive to young recruits, particularly if and where there is little consequence for these actions, even when they are caught. Therefore, it is necessary to have a robust organised crime legislation in place to stop criminals from profiting from their nefarious activities and encouraging crime, thus returning the money obtained illegally back to the community. As the member for Malvern stated, it seems though that when considering this bill contextually, this bill was brought forth to rake in more money and as much money as possible for the state coffers, particularly when we've seen today projected debt to rise to $187.8 billion by 2027 to 28, and interest growing to $25 million a day. Victoria is indeed broke, with a growing debt level and growing interest payments, which, as we've seen under this government, has meant 54 new taxes, cuts and less money being available for services and infrastructure, as well as for tackling crime. So Victoria is broke and needs all the money that it can get, whether that be from innocent Victorian families or bikies or drug traffickers. Money is money to this government. Under the Confiscation Act 1997, there are two pathways under which the DPP can apply for the forfeiture of the property of these suspected criminals. One is based upon a reasonable suspicion that a person with an interest in property valued over $50,000 is engaged in serious criminal activity. The other is based on a reasonable suspicion that the property was not engaged lawfully. In both of these pathways, there is a nexus of criminality. Among several other measures, Clause 24 inserts the new Division 1A of Part 4A of the Act, introducing a third pathway which will allow the DPP to apply to a court for an unexplained wealth order if there are reasonable grounds to suspect that a person's wealth exceeds their lawfully acquired wealth of at least $200,000. Once this is established, the third pathway puts the onus on the accused to justify that their wealth is lawfully acquired. An application for an unexplained wealth order must be supported by an affidavit of the police officer setting out any relevant matters and stating that the police officer suspects that a person has wealth that exceeds their lawfully acquired wealth of $200,000 or more, and setting out the grounds for the suspicion. They do not have to be suspected of criminal activity, nor is there an obligation on the Crown to prove any nexus between any unexplained wealth and criminal activity. The bill also has the purpose of providing for the imposition of debt to the state on and for the forfeiture of property of a person who is unable to satisfy a court that their wealth was lawfully acquired. The previous pathways were dependent on the person having the wealth on them or a direct link to criminal activity, for example, owning or having a controlling interest in an expensive house or car in their name. Yet for the first time, consumable wealth and wealth that has been gifted, disposed of or expended, such as the hiring of a yacht or a hotel penthouse or adult services, will be captured. This is a positive step in the right direction, as it makes it substantially difficult for crime bosses to make use of any loopholes. There are, though, concerns with this bill. This bill generally calls into question two principles which need to be balanced appropriately in order to ensure a fair society. The first is the presumption of innocence, and indeed the presumption that an individual should not have to usually explain the provenance of their personal assets in the absence of demonstrated criminality. There should, of course, be a high threshold for when the government can intervene and actively confiscate one's property. Prima facie, such conduct is in violation of norms of property ownership, freedom of citizens from unnecessary interference by the state, and the right to power. It is a coercive exercise of power not to be taken lightly. Yet, on the other hand, there is a significant public interest in organised crime figures like drug traffickers who profit from their illegal activity being subjected to stronger laws to confiscate wealth. These criminals cause irreparable harm to our community and are a menace for police officers, and it is wrong that these Tony Soprano wannabes can splash out on fancy cars, yachts, Rolexes and strippers while other Victorians suffer as a result of their criminal behaviour. Overall, the legislation must be measured and balanced in its approach, safeguarding essential rights while punishing those who perpetrate harm to our community. Unfortunately, like many pieces of criminal justice legislation that come through this House, it fails to strike the appropriate balance. In fact, this bill has been actively opposed by the Law Institute of Victoria and the Bar, believing the third pathway to be completely unnecessary and too broad without the appropriate safeguards in place to protect innocent people. The bill has been criticised by the Law Institute of Victoria on the basis that, and I quote, "The criteria for the restraint and forfeiture of wealth under the proposed new pathway would not require a nexus to criminal activity to be established, meaning that it is insupportably broad. The fact that the legislation does not require the establishment of this nexus raises the likelihood that assets will be confiscated from innocent people. This is a disproportionate amount of power to place in the DPP, providing them with a great amount of discretion to apply to the court for the confiscation of one's assets. Furthermore, there is no statute of limitations when it comes to confiscating wealth, with anything that you have used and enjoyed in the past being fair game. Indeed, statutes of limitations exist to provide legal certainty and prevent the seemingly indefinite pursuit of past actions. So technically through this bill, anything in your past that exceeds the threshold amount of money is fair game if you haven't kept your receipts. In the past, there has also been criticism levelled at the unexplainable wealth framework in Victoria and across Australia for the potential hardship caused to a defendant's innocent family members and other blameless third parties who may have an interest in the targeted property. There are safeguards in this bill that seek to prevent this, with the court being able to refuse to make an unexplainable wealth order if they determine that making the order would be manifestly unjust. In addition, Victoria Legal Aid is available for when a person is unable to pay privately for a lawyer to represent them in their unexplained wealth proceedings. And there is privilege against self-incrimination, relief from undue hardship, a requirement of evidence of the wealth alleged, and more. I should note that the imposition of the $200,000 minimum threshold ensures that the new wealth pathway is only targeted towards the most serious of cases. Moreover, while there are safeguards in place, there are still valid concerns that this bill imposes grossly disproportionate, unnecessary and draconian powers on the state to confiscate personal property, without there being a nexus between criminality and unexplained wealth. In light of this, I greatly support the amendments put forward by the member for Malvern, calling on the government to properly consult with stakeholders like the Victorian Bar and the Law Institute of Victoria to see how we can improve this bill. I also support the requirement of a statutory review of the amendments tabled in Parliament after 3 years of operation. Overall, Acting Speaker, we need to look at what we can do to stop crime and to prevent crime. We do need to take actions to stop people gaining unexplained wealth and to contribute that back to the state for use elsewhere when there has been criminality. But we need to get the balance of crime right. We have seen a growing crime rate here in Victoria. We've seen a growing crime rate on the peninsula where I am. We've seen this Labor government, those opposite, oppose some of the measures we've brought recently, even in the last sitting week of Parliament, in relation to child sex predators and trying to close the loophole there. So we need to actually take action, and I would hope that the Labor government supports some of these measures we are bringing to tackle the crime rate here in Victoria. Thank you, Acting Speaker.